Welcome to class today. Today, we'll be looking at a very important topic titled Labor and Employment Law. Nigerian labor and employment legislation creates a comprehensive regulatory system governing workplace relationships among employers, workers, and trade unions. The legal framework establishes fundamental employment standards, fosters productive industrial relations, and provision mechanisms for resolving workplace disputes. The system encompasses critical areas such as wage regulations, work schedules, employment termination procedure, and work protection measures, with the Nigerian Labour Act serving as the cornerstone legislation. Principal legal structure. Nigerian Labour Act. These foundational statutes provide the primary regulatory framework for employment relationships in Nigeria, delineating the rights, responsibility, and obligation for both employers and workers. For employment standards, we have wage protection, work schedule regulations, leave entitlement, employment termination protocols, anti-discrimination measures, retirement security, workplace safety standards, workforce reduction procedures, industrial relations. Wage protection. The National Minimum Wage Act establishes mandatory minimum compensation levels that all employers must observe across Nigeria. Work schedule regulation. The Labour Act defines standard working hours and mandates additional compensation when employees exceed these prescribed limits. Leave entitlement. Workers gain right to a minimum 6-day annual leave period following 12 consecutive months of service. Employment termination protocols. Both the Labour Act and individual employment agreement establish procedures for ending employment relationships, including required notice period, anti-discrimination measures. The Discrimination Against Persons with Disability Prohibition Act specifically prohibits workplace discrimination against individuals with disabilities. Retirement security. The Pension Reform Act requires employers to contribute to workers' retirement savings accounts, ensuring financial security for employees post-employment years. Workplace safety standard. Various regulations during various regulations under Labour Act establish health and safety requirements to promote workers from occupational hazard. Workforce reduction procedures. Specific laws and regulations govern redundancy processes, outlining legal requirements and recommended practices for workforce reductions. Industrial relations. The legal framework addresses collective bargaining processes between employers and labour organizations, facilitating structured negotiation. Fundamental objective. Nigerian Labour and Employment Law seeks to establish equitable workplace environment that balance employer operational needs with worker rights and protection, ultimately supporting the country's broader economic development goals through stable and fair employment practices. What are the main sources of employment law? The main sources of employment law in Nigeria are as follows. The Constitution of the Federal Republic of Nigeria 1999 has amended the Constitution. The Labour Act Chapter 11 Laws of Federation of Nigeria (LFN) 2004. The Labour Act. The federal law enacted by the Nigerian Assembly, Nigerian National Legislative Houses, and the state laws enacted by the House of Assembly, the state legislative authority of each state that relate to labour and employment pension and workplace compensation, including the following: Employees Compensation Act 2010, HIV and AIDS Anti-Discrimination Act 2014, Immigration Act 2015, Industrial Training Fund Act Chapter 19 LFN 2004 as amended, National Health Insurance Authority Act 2002, National Housing Fund Act Chapter 45, okay, Elephant 2004 as amended, Pension Reform Act 2014, Trade Dispute Act Chapter T8, Elephant 2000. What are the main sources of employment law? Well, the Trade Union Act Chapter T14, Elephant 2004 as amended by the Trade Union Amendment Act 2005, the National Minimum Wage Amendment Act 2024, National Industrial Court Act 2006, Factories Act Chapter F1, Elephant 2004, Finance Act 2021, National Income Tax Act. We have the Discrimination Against Persons with Disability Prohibition Act 2018, Lagos State Special People's Law 2011, Nigeria Oil and Gas Industry Content Development Act 2010, Guideline for the release of staff in Nigeria Oil and Gas Industry 2019. The staff release guideline issued further to the provision of Petroleum Drilling and Production Regulation in 1969 as amended, made pursuant to the Petroleum Act Cap 10 LFN. Now the Petroleum Industry Act 2021, the Petroleum Act, Nigeria Data Protection Regulation 2019 issued by the National Information Technology Development Agency, Nigeria Data Protection Act 2023, Business Facilitation Exclusiveness Provision Act 2022, Decision of Nigeria Court Case and International Convention Treaties and Protocols relating to labour, employment, workplace, industrial relations, or matters connected therewith that have been ratified by Nigerians. Employment categories and legal protection. Worker classification system. Nigerian employment law established two primary worker categories with distinct legal framework, while the workers and non-workers. The workers, the individuals engaged in manual labour or clerical tasks are received comprehensive protection under the Labour Act, which serve as Nigerian principal employment legislation. The Labour Act establishes mandatory minimum employment standards and working conditions specifically for this category. The non-worker employees, this classification encompasses personnel in administrative, executive, technical, or professional roles. Their employment relationships are primarily governed by individual contractual agreements rather than statutory minimums, providing greater flexibility in terms and conditions. Notably, other employment-related legislation in Nigeria does not differentiate between these worker categories, applying uniform standards across all employment. Employment contract requirement. Written contract obligation. While the Labour Act acknowledges that employment agreements may be oral, written express or amplified section 7 mandates that employers provide written contract to workers within 3 months of employment commencement. Non-worker contract standard. No statutory requirement exists for written employment contracts for non-workers. However, written agreements are strongly recommended to ensure clarity and facilitate future reference regarding employment. Mandatory employment standard. The Labour Act establishes comprehensive minimum employment conditions that employers must provide to workers, including written employment statement detailing job nature and responsibilities, specifying notice periods for employment termination, wage rates and calculation methodologies, payment procedures and frequency, working hour regulation and holiday provisions, sick leave entitlement and compensation policies, maternity leave provision for female workers. So, collective bargaining framework, we have the industry legal negotiation, company legal labor arrangement. So, in rural labour law, we have the employment relationship structure, contract requirements, wage standard, working hours regulation, health, safety and anti-discrimination, employment termination, child labour protection, collective labor relations. Thank you for listening.